All right. Hi, folks. This is Curt and welcome to another edition of Fire Law Roundup for April 23rd of 2024. A couple of apologies, and let me just straighten out this one thing here. All right. Hi, folks. This is Curt and welcome to another edition of Fire Law Roundup for April 23rd of 2024. A couple of apologies, and let me just straighten out the. All right. Hopefully, we didn't lose anything there. Um, I'm not sure. I think we might have by me doing that, but at any rate, hopefully not. But welcome. A couple of things. Apologies for not getting the video out yesterday. I had a funeral. My uncle, who's a police officer, passed away, and so that kind of was problem number one. Problem number two is Brad and I planned on doing it today, and Brad had a death in his family. His mother-in-law passed away this morning, so we're a little bit off our game here, but and it's unfortunate because last week was a really interesting week. There was a couple of cases I was really looking forward to discussing with Brad, but I'll do my best here to cover them. And the first one is the case out of Sacramento. We've got another in a long line of cases where firefighters were, in this particular case, is really two ways these happened, but this is one of them where firefighters are dealing with someone who they cannot get under control. This gentleman happened to be having some sort of a diabetic related episode, and they requested the police to respond. The police subdued him, and in the process of subduing him, put him in a prone position, and he ended up having a heart attack and passing away. The family, of course, characterized it as civil rights violation, wrongful death, false arrest, excessive force, and so on. And I'm certain from their perspective, that's how they saw it. But at any rate, they ended up suing. I noticed, at least as far as I could tell, they didn't sue the police officers. They sued all of the firefighters that were on there. And from the way that I understood it happened, it was the police that actually did the restraint. But at any rate, the settlement here calls for a $4.5 million settlement with the family of the gentleman who passed away. Again, I just keep seeing cases. I put several in the database this week. I can't cover them all, but added several, and we just keep seeing them. They kind of occur in two ways. One is where we've got the police apprehending someone and we end up responding in because the person, or sometimes the police officers on scene, suffered some injuries, and something happens to the person being arrested, and we end up finding ourselves named in the lawsuit. That's sort of one way. The other way is, this one, which is where we're dealing with a medical emergency, but that causes the person to be difficult for us to deal with, perhaps combative. And, in this case, I guess they couldn't get an IV. He was resisting that. And, we end up with this $4.5 million settlement. Certainly unfortunate that the man passed away, but, it's representative of something that we're seeing an awful lot of. Next case here is out of New Jersey. It's a race discrimination case filed by a firefighter who claims that he was subjected to some inappropriate language, no doubt, some inappropriate language and some treatment. And he claims that all of the things that happened to him after he filed the complaint then was retaliation, which, whenever someone files a complaint, we've got to be very cognizant of the risk of a retaliation claim. And again, we don't know all of the details. All we know is that a lawsuit has been filed, and I believe it's the Hamilton County Fire Department. So, interestingly, I thought it was, again, this is something I want to talk to Brad about because he's a little closer. He has an attorney in his office that practices in New Jersey, and they didn't sue under Title VII or under the state's employment discrimination law. They sued under the state's Conscientious Employee Protection Act, which is intended to protect employees who complain or report things that are improper. And I thought it was an interesting strategy. I'm not 100% sure why. Usually you would go straight for race. This firefighter was African American, and why they wouldn't have gone straight for Title VII and a state law race discrimination claim. I'm not sure. Possibly it may have to do with the EEOC when you're filing under Title VII and many times under state law race discrimination. You've got to file with the EEOC within, and then you can only go back, like once you file, you can only go back either 180 days or 300 days, depending on the jurisdiction. And so perhaps that might have played a strategic role in their decision to go under this Conscientious Employee Act. So don't really know. That was kind of case number two. Case number three, interesting case, and Bill Macarone delivered his class on this topic, which is chief officers and other officers, captains and lieutenants as well. But certainly the hot topic seems to be chief officers and their entitlement to overtime. And 6 battalion chiefs within the Wilmington Fire Department filed suit back in, I believe, might have been 2023, alleging that they were improperly classified as exempt employees and therefore not provided with overtime for the extra hours that they worked. The city, of course, denied that and said that they were properly classified as exempt and not entitled to overtime. They must have kind of gotten together on the issue. And it is, honestly, it's a close call in many of these cases. Some of it's going to come down to the judge and how the judge views it. But at the end of the day, they ended up settling the case, and they agreed going forward that the battalion chiefs would get overtime. And that called for $459,000 settlement. I get the breakdown here. It's about $215,000 in back pay. So that, divide it by 6 there, and you've got what each of them is going to get. So we're at 30-something thousand. Liquidated damages, so that's another 30-something thousand. And liquidated damages, whenever there's a wage and hour violation, you get double damages, basically. So whatever your damages were, you get that in what's considered to be liquidated damages. So they'll get another total is $430,000 if my math is correct. And I was actually surprised that the attorney's fees were so low for a federal court case, and all of the discovery and all of the different things that go into filing a federal court lawsuit. They ended up with relatively low legal fees, $30,000 in attorney's fees. So at the end of the day, the city settled for $460,000 on that overtime case. So we're seeing cases go both ways, and I use that metaphor of a close play at second base, where you don't know what the umpire is going to call. Well, we don't know what the judge is going to say. Is this particular battalion chief, or this in a different department, is that district chief going to qualify for the exemption, or are they going to be an hourly employee? And one of the big issues, are they a first responder, or are they is their primary duty management of the enterprise? So that's I don't know how many federal judges we have in the United States, several hundred, and we've got, I'm sure, several hundred different opinions on whether or not these people should be entitled to overtime. And I think sometimes that is really what drives it, but some of it is the arguments that the attorneys are able to make in a case like that. So, but that one's settled. Very common type of lawsuit that we're seeing today. And next case here, this is one I want to talk to Brad about. I thought it was fascinating. It's a trademark case out of the FDNY, and there was a medic who had sort of, I don't know if he originated the idea, but bottom line is he developed a conference called the Medical Special Operations Conference. He was a paramedic, but also assigned to special ops in FDNY. And so he had delivered the conference in conjunction with FDNY, but also done it on his own using the same term. And but FDNY had used the term special operations as well. So bottom line is he trademarked the name. And initially you know, if you're going to get a trademark, there's a patent and trademark office in Washington, D.C. It's really kind of a subspecialty of the law, but you go and apply and they look at whether or not it is truly a distinct type of trademark, like Coca-Cola would be, you know, an example, or Xerox or Apple computers and so on. So it makes sure that it is distinctive. And the other part of a trademark is that it can't just be sort of a generic name or descriptive. Okay, so if I said sunny day, so sunny day is you know, it's descriptive. The sun is out and it's during the daytime. You know, so it's not really really trademarkable, put it that way. But there are some complex alternatives that folks can you know, apply under. Bottom line is he initially was turned down on the trademark. He got the trademark, and then he sought to try to stop FDNY from using the trademark. That prompted FDNY to then file suit, and actually in the name of the city of New York, they filed suit against him, trying to challenge the mark and saying, look, that's not a valid mark. It should not have been issued. And even if it is, you can't enforce it against us. The trial court ruled in favor of the medic, and FDNY appealed that, and the Second Circuit went up to the next level up, just below the U.S. Supreme Court, and they said no. They said this is not really a distinctive mark, and it's really, you know, the court should not have granted him the decision, you know, in his favor, that it really, you know, FDNY should be allowed to use that trademark. So it's got to go back down. There's some other issues that have to be decided at the trial level, but it's you know, it's a pretty interesting type of a case. If you're into intellectual law, this area of the law is what we call intellectual law. And I studied it in law school because I was, you know, a little bit of a musician, and looking at the copyright issues and the musicality, and it's, you know, there's a whole subset of intellectual law that looks at music and that. So that's primarily why I took an interest in it, but certainly trademark is part of it as well. So FDNY prevailed in that one. Next case here, and the last case that we're going to talk about is a case out of St. Louis where a firefighter was killed, died at a fire in the line of duty. And the family, his parents, are suing 3M and Scott and, you know, several other people that were responsible for providing the service, providing the SCBA, alleging that the SCBA was somehow faulty, and the pass device in particular didn't go off. And I think I've got the complaint. Let me kind of put the complaint up here as well so you can see it. I apologize. I don't know why the copy I have, you can see the looks like the things on the back are sort of bleeding through, so you know, makes it a little bit hard to read. But again, it was the parents of the firefighter. Let me get his name right here. Benjamin Polson died at a fire on January 13th of 2022. And so his parents filed suit against 3M, who's the parent company now of Scott. But we've got Scott Technologies, and I believe that's the person who actually sold, or that's the agent. I'm sorry, that's the agent for service of process. So at any rate, we've got this suit, and what they're alleging was that the SCBA 5.5 Pro self-contained SCBA and personal alert safety system pass device was designed, manufactured, and sold by the defendants, and it was defective, causing him to run out of oxygen, run out of breathing air, and die from smoke inhalation, and that the pass device failed to properly alarm. So I don't really have much more detail than what's in the complaint. But it's not the first time a St. Louis firefighter has passed away and sued an SCBA manufacturer. It was a very big lawsuit. I think it was against Survivor a number of years ago, and that resulted in a fairly large award to the family of the deceased firefighter. So we'll see. We'll see how that comes out, but certainly one that we should be looking at. In fact, yeah, that looks. Oh no, that's a different case. But apparently they're listing some of the other cases where Scott and 3M have been sued for the SCBA and past device problems in the past. So difficult to deal with, but it is what it is. So, so that's going to wrap it up. It's going to be a relatively brief roundup this week, and hopefully we'll be back on track next week. And hopefully things things at Brad's funeral. I know Brad's situation. It's not even a funeral. She just passed away this morning, but I know he was very concerned about his wife's well-being and so on. So, but I think that's going to do it for another edition of Fire Law Roundup, and we'll see you again next week.